talking about the next subsection of the rules, specifically the lawyer-client relationship. So this subsection of the rules makes up 10 to 16% of your total MPRE exam. So this is a very highly tested subsection of the rules. The first rule that I want to talk about is the first one listed. It's all about the formation of the lawyer-client relationship. So first, taking it from the top with the basics, the rule tells us that our lawyer-client relationships are formed by contract. We as lawyers are considered to be both the client's fiduciary and their agent. Then the rule gets more specific about how we can form these lawyer-client relationships. And it tells us that we first form these relationships, or one way we form these relationships is when a person manifests an intent that the lawyer provide legal services and the lawyer agrees. So let's stop there. I feel like this is the most basic, straightforward way in which most people think about lawyer-client relationships forming. A client reaches out to you, or a prospective client reaches out to you, you guys communicate about that person's legal issue, and you agree to represent them. You have therefore formed this lawyer-client relationship. The second way these lawyer-client relationships are formed are a little different. This is when a person manifests an intent that the lawyer provide legal services and the lawyer fails to make clear that he or she does not plan to, and the lawyer knows or should know that this prospective client is reasonably relying on the lawyer to provide services. So to stop there, this is like the opposite of what we just said. This is a situation where a prospective client reaches out, gives the lawyer information, and for whatever reason is reasonably relying upon that lawyer's help, and the lawyer fails to make it clear that they're not representing that prospective client. In other words, whether or not the lawyer likes it, they're now that person's lawyer. So remember something that I said in the previous video. These rules place the burden on us as the professional to make it clear whether or not we're in a relationship with someone, and if we are, what the terms are. And if we're not clear, unfortunately, we're going to get the short end of the stick there because we might find ourselves violating these rules. So let's look at a few examples on that point. Client Clancy calls lawyer Larry and leaves a voicemail asking Larry to represent him. Larry doesn't return the client's call. It's unreasonable for Clancy to believe that Larry will represent him. Stopping it there, just to reflect on that example, there's nothing in this basic fact pattern that gives this client any reason to believe the lawyer is representing him. In fact, the lawyer never calls him back. So there is no lawyer-client relationship developed here. Now compare that to the second example. Client Clancy calls lawyer Larry with a time-sensitive matter and asks Larry to represent him. Larry asks Clancy to send him additional information and tells him that he'll call Clancy back in the next couple of days. Larry never calls Clancy back, and a statute of limitations in Clancy's case runs. It's likely that a lawyer-client relationship was formed because although Larry never formally agreed to represent Clancy, Clancy reasonably relied on lawyer to provide legal services. So here, what lawyer Larry could have done is just make it clear that he wasn't taking the case on unless he reached back out to the client or something like that. But the lawyer failed to do this, and therefore a lawyer-client relationship arguably formed. Now, the third instance, or way in which these lawyer-client relationships formed, I find is a way that people forget about until they're faced with a question, and then they ultimately get the question wrong. So hopefully now I can put this on your radar. You enter into a lawyer-client relationship with someone when a court or tribunal appoints you as a lawyer to represent a client. So remember, there are 3 ways to form a lawyer-client relationship. The next part of the rule that I want to discuss is all about scope, objective, and means of representation. And first things first, what are those types of decisions that you as a lawyer get to make versus what are those types of decisions that the client gets to make? So let's break this down. Client decides the objectives of the representation. In other words, what do they want? Ideally, what is the outcome they're seeking? 2, whether to settle. So whether or not they want to go to trial is up to them. And the expense to be incurred. Ultimately, your client is funding this whole thing. They've got to pay you, and they've got to pay the fees and expenses associated with the transaction or with the lawsuit. So they get to make those types of financial decisions. Now, if you're dealing with a criminal client, they have a few extra types of decisions they get to make due to their constitutional protections. So they get to decide whether or not they want to enter into a plea, waive a jury trial, or testify. Keep in mind that that right to testify, again, is specific to criminal defendants, not civil clients. So then what does a lawyer get to decide? Well, they get to decide the technical, legal, and tactical matters of the case. So I like to think of this as think about why someone might hire you based upon your experience in a certain field, of course, your expertise, your knowledge. So really any decision that falls back onto one of those things is a decision that you as the professional gets to decide. Now, when it comes to fundamental disagreements between lawyers and clients, because of course these happen, not everyone gets along. If the lawyer and the client can't agree after attempting to resolve their agreement, then the lawyer may withdraw or they could simply get fired by the client. So to be clear here, we're going to talk about mandatory versus permissive withdrawal here in the next few minutes. This is one instance of permissive withdrawal. Note the rule says may, so you don't have to withdraw, but you can. But I do want to point out the MPRE tip. If the client matters before a court, then an attorney must comply with the applicable law requiring notice and permission to withdraw. And if the court doesn't grant permission, then you can't withdraw. The next rule that I want to discuss is counsel and assistance within the bounds of the law. So first things first, lawyers shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but the lawyer may discuss the consequences of any proposed course of conduct with the client and may make a good faith effort to determine the validity, scope, and meaning or application of the law. So let's stop there. At a very basic level, this rule is saying you can't help your clients break the law. You can't do that. However, it's not likely that our MPRE questions will be that straightforward. So I want to look at the rest of what this rule is saying. The rule does go on to say that you as the lawyer are allowed to discuss the consequences of your client's proposed course of action with them and to try to determine the scope and the validity of the law as it relates to them. So a few things to think about here. If your client comes to you with this proposed course of conduct that you know is very clearly illegal, you can hear them out and then explain to them why that's not a good idea. Explain to them why you can't help them. Explain to them why that is criminal or breaking the law. And you can even help them come up with a better legal alternative. So you can do that. But another way to view this rule is think of a tax attorney, for instance. I'm not a tax attorney, but I would think that a lot of people, like businesses maybe, hire tax firms or tax attorneys to make sure that they're paying taxes appropriately and therefore not violating the tax code. However, they don't want to pay more taxes than they're legally obligated to pay, right? I mean, who wants to do that? We don't want to break the law, but we also don't want to pay more just for no reason at all. So in that instance, a tax attorney is really truly trying to determine the scope and the validity and the application of the law to their specific clients, to help the clients reach their goal of course, paying taxes and being in compliance of the law, but not overpaying, because again, who wants to overpay taxes? The next part of the rule says that lawyers can limit the scope of their representation if that limitation is reasonable and if the client gives their informed consent. So you can limit the services that you will provide to a client, but the limitation must be reasonable. So if you know what you're proposing to the client won't work or won't be reasonable, then you can't place that limitation on your services. And further, your client needs to consent to this limitation. It's not something that you can just unilaterally do on your own. So look at your example here. If a client needs advice to handle a common legal problem, the lawyer and the client may agree that the lawyer's services will be limited to a brief telephone consultation. However, if the time allotted is not enough to give the client good or thorough advice, this is not permissible. So if someone comes to you with a legal issue and only has a certain amount of money to spend, and you know based on your rate and how long the task will take, that the amount of money they have to spend is not enough, and yet what you're doing for them is not reasonable in the grand scheme of things, then you cannot limit your representation in that matter. So shifting gears just a little bit to the termination of the lawyer-client relationship, and I alluded that we would be talking about this portion of the rules. So first things first, you'll note that there are two types of termination here. Mandatory, meaning you must withdraw as the lawyer, and permissive, where you may withdraw. So before we dive into those two parts, you'll notice that the rule first outlines those instances of mandatory withdrawal. And in fact, there's 3 instances in which you must withdraw. So if I were you, after we've reviewed this, and of course you're going to come back to try to memorize these rules, I would first focus your energy on memorizing these 3 instances where you must withdraw. Why? Because then you'll know that every other set of circumstances is a permissive withdrawal. Think about it. If you get a fact pattern on the MPRE and you know it's testing withdrawal, you'll think to yourself, well, there's 2 types of withdrawal, permissive and mandatory. And then you'll ask yourself and you'll evaluate based on the facts, is this one of those circumstances where withdrawal is mandatory? If the answer is no, you know then it falls into one of those permissive categories. And I find that's half the battle with these questions, is discerning if it's a must or may situation. So what are those 3 situations in which mandatory withdrawal is required? Well, the rules tell us that a lawyer must withdraw if this representation will result in a violation of these model rules of professional conduct or other law. In other words, if your continued representation would, say, amount to some sort of criminal act, you have to withdraw. So I really want to stress here what the key is in this rule. It's that the crime or the fraud or the rule violation in question has not yet occurred, but it will occur if you continue to represent the client. So the purpose or the policy behind this rule is that we want you to withdraw, hence you have to withdraw in this instance because we don't want you to break the law or these rules. And by withdrawing, you can avoid breaking the law or violating these rules. So the second instance is mandatory withdrawal, is when the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client. So if you're a lawyer representing, let's say, a big bank, and you've represented them for years, and unfortunately with old age, you now have a rather debilitating disease, and it causes you to be in and out of the hospital quite frequently, where you just can't take client calls or manage client deadlines anymore. In that instance, you must withdraw because you are literally unable to handle your client matter. The third instance of mandatory withdrawal is if the lawyer is discharged by the client. Remember, if you're fired, you have to take steps to withdraw, and a lot of people forget this instance. So if your client lets you go, then you must comply with the rest of these rules here to effectively withdraw. So remember, those are the only 3 instances of mandatory withdrawal. The rest are all permissive. So let's talk about permissive withdrawal. You may withdraw if it can be accomplished without a material adverse effect on the interests of your client. And to me, that's like the backbone of this rule. You always want to double check if the withdrawal would have some sort of material adverse effect on the client. I think that this is a good gauge for determining if withdrawal would be proper. The next instance is if the client persists in a course of action involving the lawyer's services and the lawyer reasonably believes that course of action is criminal or fraudulent. So for example, if you're representing someone that's been charged with embezzlement, and let's say at the beginning things go great between the 2 of you, you're agreeing on everything and on the course of conduct, then as trial emerges and gets closer, your client keeps nudging you and telling you what he wants you to do, and you believe if you take that route, it's criminal or it's fraudulent in nature. And you keep telling your client, no, I can't do that, I won't do that. And they don't care, they keep persisting. That would be an instance where you'd want to take steps to withdraw. Now the key is though, can you withdraw without a material adverse effect on your client? In other words, timing would be really important here. If you're trying to withdraw the eve of trial, that's probably a problem and you might not be able to do so. But if you're withdrawing with enough time prior to trial, it's likely not a problem at all. The third instance of permissive withdrawal is if the client has used the lawyer's services to perpetuate a crime or fraud. Let's stop here. Please don't confuse this with the rule above about mandatory withdrawal. Remember, the purpose behind mandatory withdrawal in the first instance is we want you to withdraw. You have to withdraw if withdrawing would help you avoid violating the law or these rules. Now, if you're dealing with a client who's a really good liar, let's say, and you've believed your client's lies and you help your client do something that you later find out is criminal or fraudulent because they've been lying to you, well, now you're in this position of permissive withdrawal. You can withdraw if you want. I would guess most lawyers would want to because they wouldn't want their name associated with that type of course of conduct, but you don't have to because the law's already been broken. It's not like by now withdrawing, you can avoid breaking the law. If you've already broke the law, it comes into a permissive withdrawal category. Permissive withdrawal also exists If the client insists upon taking an action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement, we briefly talked about that rule already. Or if the client fails substantially to pay the lawyer or to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So if your client just straight up doesn't pay you, and after multiple warnings, it looks like they're not going to pay you and they owe you a lot of money, that would be good grounds for permissive withdrawal. Or if the representation will result in unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client. Or if other good cause exists for withdrawal. So the way I like to think of this rule, generally speaking again, is that this is not an exhaustive list. Why? Because that last kind of factor here says if other good cause exists. So if there's another set of circumstances that appear to be good cause, but they don't fit perfectly in one of these other instances, it's likely a situation for a permissive withdrawal. So now that you know the difference between mandatory and permissive withdrawal, how do you withdraw if you have one of these instances? Well, generally speaking, a lawyer has to comply with the applicable law that requires notice to or permission of a tribunal when terminating a representation. Most jurisdictions require permission from the court to withdraw. So be on the lookout for a fact pattern that tells you your lawyer is in a jurisdiction that requires permission from the tribunal, and when the lawyer asks for permission, the court doesn't give it. Well, if the court says, no, you can't withdraw, then you can't withdraw. You have to continue representing that client. And upon termination of representation, a lawyer shall take steps to the extent reasonably necessary to protect the client's interests, such as giving reasonable notice to the client, allowing time for them to employ other lawyers, surrendering papers and property that belong to your client, and refunding any advance payment of fees or expenses that have not been earned or incurred, and returning property that belongs to your client. So the big takeaway here is even though you are terminating your representation, you still have to have your client's best interests in mind throughout this whole process. So you need to make sure that you aren't just like leaving them high and dry, for instance. The next rule that I want to talk about is all about money or fees. We get lots of questions on fees. People sometimes get confused by these rules, so I thought it was a good use of our time. So the first rule that I want to discuss about fees is our general rule. It tells us that a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or for an unreasonable amount for expenses. And then it tells us that the factors to be considered in determining the reasonableness of a fee include the following. So I want to stop there before we even talk about any of these factors. This list is not exhaustive. So what I would do if I were you is I would be very familiar with these factors. That way you can pick them out very easily in a fact pattern if you needed to. But please note that everything and anything could be considered when trying to determine whether or not a fee is reasonable. In other words, you're not limited by this list. So the big takeaway is this is not necessarily a rule that I would tell you to memorize. Should you be very, very familiar with it, of course. But there are other rules where the list is exhaustive, so memorization of it becomes key. This is not one of those rules. Again, these are all just factors, but in the grand scheme of things, everything and anything can be considered when determining whether or not the fee being charged is reasonable. So let's look at some of these factors. The time and labor required, as well as the novelty and difficulty of the questions involved and the skill requisite to perform these legal services properly. In other words, is this super time intensive? Is this something that requires a great amount of expertise that very few lawyers have maybe? Because to me, those two things mean that the fee is likely going to be greater that you charge. The second factor, the likelihood, if it's apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. So if you take this case on and it means you can't really work on anything else, and the client knows that, that likely means your fee will be higher. You can look at the fee customarily charged in your locality for similar legal services, the amount involved, and the results obtained. Time limitations imposed by the client or the circumstances. If they come to you at the last minute and you have to set everything else aside, that might be an indicator that you could charge a greater fee. The nature and length of the professional relationship with the client, the experience, reputation, and the ability of the lawyer or lawyers performing these services, and whether or not your fee is going to be fixed or contingent. So the general rule is your fee must be reasonable. The next rule that I want to touch upon is that fees have to be communicated. This is a rule that I see a lot of people get wrong. They think the rule says something that it doesn't. So let's look at the plain language of the rule first. It says the scope of representation and the basis of the rate or the fee and expenses for which the client is going to be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall be communicated to the client. So what this is saying is, ideally, if a client comes to you and you guys form a lawyer-client relationship, what we would like is for you to outline in writing your fee agreement. Why? Because everything's always better in writing, right? Because now we have a writing to reflect upon and to remind ourselves of what our agreement is. But what this rule says, though, is we don't necessarily have to have fee agreements in writing. You'll notice the rule specifically says these agreements are preferably in writing. It doesn't say they have to be in writing. So this means you could have an hourly fee agreement with your client that you've reached on the phone, orally, and you might never put it in writing, and you aren't in violation of this rule. The other thing I want to point out is that the rule essentially recognizes there are instances in which a client might come to you and you need to get to work immediately before you kind of formally set up a fee arrangement. In other words, you might have to get started on the case and then you get past the first big hurdle or the first deadline, and then you and your client can kind of have that more formal discussion that you would have originally had at the outset of your relationship had you had the time. That's okay too, assuming that you couldn't have had the conversation initially. So the big takeaway here, while we have to communicate our fees to our client, they don't necessarily have to be in writing because the rule discusses that they are preferably in writing. And again, we preferably do this before we start working for our client, but if you can't, you are allowed to communicate these fees or fee arrangements within a reasonable time after commencing representation. The next fee rule I want to discuss is all about a contingency fee. So first of all, what are these? We start by defining it. A contingency fee is when the lawyer will collect a fee only if the client obtains a favorable outcome. Generally, this is a percentage of whatever the client recovers of the case. In other words, if your client wins, you get paid, is kind of how I would summarize this. Now, these arrangements are special, not by virtue of just their definition, but also by how these rules treat them. And that's because the rules state that contingency fee agreements have to be in a writing signed by the client. So remember, the prior rule said that generally fee arrangements, in other words, like an hourly or flat fee arrangement, could be oral. You don't have to have it in a signed writing. Here, we have to have contingency fees in a signed writing. And specifically, our writing needs to outline all of the specifics of our agreement. The percentage that goes to the lawyer in the event of settlement or trial or appeal, litigation and other expenses that are going to be deducted from the recovery, and whether or not these expenses get deducted before or after the contingency fee is taken. Any expenses for which the client will be liable for, whether or not they win. So in other words, we need to know exactly how they're calculating their fees. And more specifically, in addition to their initial signed agreement that the client signs, there is a second writing requirement. I like to think of this secondary writing requirement as essentially a receipt. Upon a conclusion of the matter, a lawyer shall provide the client with a written statement stating the outcome of the matter, and if there's a recovery, showing the remittance to the client and the method in which it was determined. Now, this second writing doesn't have to be signed. It's probably a good idea to get it signed, but these rules do not make that second writing have to be signed as a requirement. Now, please note, though, contingency fee agreements are not allowed in every single type of case. Specifically, there are two types of cases you're not allowed to enter into a contingency fee agreement with. The rules say in domestic relation matters, the payment or amount of which is contingent upon the securing of a divorce or upon the amount of alimony or support or property settlement in lieu of it, or in a criminal matter for representing a defendant in a criminal case. So I want to clarify this rule. In any criminal matter, if you have a defendant who comes to you and wants you to rep them in a criminal matter, you can't enter into a contingency fee. You can charge them hourly or a flat fee. In a domestic relations matter, if you have a client that comes to you because they want a divorce, you can't charge them a contingency fee. Now, the one caveat is if a client comes to you and they already have a divorce, or they already have a property settlement agreement, or they already have a spousal support award order, and they're seeking enforcement of it. For instance, maybe a woman comes to you and she got divorced from her husband last year, and the court requires her husband to pay her spousal support, and he's just not paying it. Well, in this type of instance, you could enter into a contingency fee arrangement with her and helping her enforce that already existing court order, because now this doesn't look like a domestic relations matter anymore. Instead, this almost looks like a collection case, right? You have the court order, you're just helping her enforce it. So in that instance, you could take a contingency fee. So always read your fact patterns very carefully on that point. So the last rule that I want to cover is still on fees, but we're just going to shift gears a little bit, and it's about fee sharing. So the general rule is lawyers shall not or should not split fees with another lawyer. But of course, there are some exceptions you need to have on your radar. Specifically, there are two. So the exceptions state that a division of a fee between lawyers can be made if, one, two lawyers work on a case together and these three requirements are met. So I take this to mean two lawyers from separate firms come together to work on a case. They can share fees if they do the following three things. First, the fee division is proportional to the services performed by each lawyer, or each lawyer is assuming joint responsibility for the matter. Two, the client knows about this arrangement. They agree to this arrangement, including how much money each lawyer is going to make, and this is confirmed in writing. And lastly, the total fee is reasonable. I just take this to mean if you hire a lawyer and they need outside help, and they do get outside help, they can't now increase the fee just because they got help. It has to remain reasonable. The second exception to this rule is lawyers that are part of the same law firm can share fees. And that's just because this is necessary for law firms to work. So if you are part of a big law firm with 100 attorneys, there's fee sharing going on, and that is permissible under this exception. So the big takeaway, though, is you'll notice any sort of forwarding fee or referral fee is not allowed under the ABA Model Rules of Professional Conduct. So keep this in mind. This is a confusing point for a lot of people because a lot of other jurisdictions do recognize referral fees and they allow them, but for purposes of your exam, they are not allowed. So if you and I enter into an agreement, let's say I'm a personal injury attorney and you're a probate attorney, and we agree to refer cases to each other. And we agree that we're going to give each other 5% of the fee that we charge in those referred cases. You can't do that under these rules because that's considered a referral fee. Now, the ABA model rules recognize something called a reciprocal referral agreement that comes up later in the course. So that wraps up this subsection of the rules.